Good morning, ladies and gentlemen, and welcome to another episode of PLA with myself, Nick, and Bruno. We've got three questions today. We're dealing with time frames and termination when it comes to lease agreements, and then we'll be dealing with fair wear and tear with Nick, and also clause 11 of the TPN lease. The first question then, Bruno, goes out to you, and this is regarding the time frames and termination of lease agreements. When it comes to the 7-day notice or a calendar month, obviously the difference between termination and then cancellation, no fault cancellation and fault cancellation. Perhaps just take us through that for our agents and viewers because there's been a repetitive in terms of confusion. So just give some clarity in regards to those, please.
So let's have a conversation around how leases come to an end. And I think that's maybe the best way to describe it. How does a lease come to an end? Now, there's numerous ways that a lease can come to an end. The one that we most commonly get asked about as attorneys, obviously, is when somebody does something wrong, like the tenant doesn't pay rent, then the lease is cancelled, right? But there's other ways that a lease comes to an end. For example, maybe the time runs out in a lease and it's time for the tenant to move out. That's another way a lease comes to an end. A lease may also come to an end. Month-to-month leases may come to an end if a person gives that month notice requesting that the tenant move out, or the tenant gives a month's notice advising the landlord that he or she is going to move out. So these are all different ways that leases may come to an end. Now, going into slightly more detail, some of the confusion around the 30-day notice versus 7-day notice, like which notice must I give, it comes again around the fact that some leases are running on a month-to-month basis. And even if the tenant fails to pay rent, and this is more often than not when it arises, on a month-to-month basis, the tenant fails to pay rent. And some of the questions come up going, but what do I do? What notice do I give him? Effectively, it's the same thing, right? Now, you can place him on terms. And you can send out a notice placing him on terms. Remember, in terms of the Consumer Protection Act, you normally give 20 business days notice requesting that the tenant rectify a breach before you're able to actually cancel the lease agreement. But on a month-to-month lease agreement, if you're sending out a 20 business day notice, or you're just giving the tenant notice that he needs to move out the property at the end of that 1 month period, it is pretty much the same thing. So there you might actually just want to focus on the time calculations to make sure that it works for you. But if you actually want the tenant to remedy the breach and you want him to pay, in that instance, send out the breach notice, because then once he pays, the lease continues. If you'd rather terminate the lease and you've had it with this tenant and you want to give him notice for him to move out, then send out the 1 month notice and advise him that the lease is terminating and that he has to vacate the property at the end of that 1 calendar month notice. This does not impact your rights to claim the rent from the tenant. So either way, you can claim the rent from the tenant. You're just choosing by which mechanism you're bringing this contract to an end. So that's one thing to remember. Remember, CPA does typically apply to most lease agreements because landlords that have investment properties are considered to be carrying on a business. There are exceptions to this rule, but I think it's maybe 2%. So it's not something that we can delve into, but we've seen a couple of exceptions. Somebody temporarily moved abroad and rented out their property. That was one exception. And for example, if you're renting out to family members and it's not really in the course of trade, you might be able to not have to send the notice in terms of the Consumer Protection Act. I hope that answers that question.
Yeah. So thank you very much, Bruno. That does certainly give us more clarity around those timeframes when it comes to termination of lease agreements. Nick, and then we'll do the second question with you. We'll start off with the fair wear and tear question. So simply put, Nick, I suppose the question really goes as, what is fair? What is fair wear and tear?
Okay, perfect. So you made that very simple.
Yeah.
the question, I'll just frame the question. So what we were asked is basically a property's been rented out and there's been some damage to the grass on the property. And after a number of inquiries, it basically was determined that the damage on the particular property was as a result of the dogs which were on the property. Okay, and they were running around on the grass in the particular circumstance, and there's been damage to the grass. Who is now liable for the grass? And so it is a question of fair wear and tear. Now, remember that a tenant is obligated while they are in occupation of the premises to look after the premises and keep it in the same condition, or at least hand it back in the same condition that the property was received in. Fair wear and tear accepted. This is always the standard, is there's got to be some sort of allowance for fair wear and tear. Okay, so you cannot expect that a person lives inside a property and there's never a scratch or nothing ever happens to the property. At some level, the law accepts the fact that there is going to be little bumps and scrapes that happen on a property by virtue of the fact that there is a living person in that particular property, and that is allowed. Okay, a person cannot be expected to have the property in precisely the same condition, and certainly a tenant is not expected to hand back a property in a better condition than that which they were received. Okay, so it's simple. The law accepts a certain level of bumps and scrapes, which we call fair wear and tear. Now, what fair wear and tear is a question that has to be asked in every single circumstance that there is when a tenant occupies a premises. Okay, we often get questions from clients, well, what is this fair wear and tear thing? And the truth is, we don't know. It entirely depends on the facts of the particular circumstances and what we can attribute to normal usage within a property. The fact that, for instance, whenever I've had tenants move out, maybe there's some lines on the wall as a result of, an end table or the bed, which has been sitting against the wall. That is something that is fair wear and tear. Whereas, your tenant breaks off some taps while using the taps aggressively, maybe that's not fair wear and tear. Maybe that's negligent conduct in the circumstances. But the point is, this is an assessment that has to be made on a case-by-case basis to see exactly what fair wear and tear might be in the circumstances, and then you deal with that in the particular circumstances to see whether it's actual negligence and whether the tenant is liable, or whether it's something that can be just accepted as normal use. So in this particular question, we've got someone who's obviously lets out a premises. We assume that obviously the lease agreement allowed for dogs to be housed on the particular premises during the lease period. And the fact is that if you have a property where you're going to allow dogs to occupy the premises along with your tenants, you are also going to have to accept that there is going to be some fair wear and tear along with the animals that are occupying the premises. Remember, you as a landlord do not have to allow anyone to keep an animal on your particular premises. You're perfectly entitled to rent out your property with a massive garden and still say, I'm not allowing any pets on this particular premises. And the reason you do that is you know that animals come with a certain level of degradation to a property, be it, scratches or digging up plants or whatever the case is. These things do happen, and it's just part of the fair wear and tear of a property of having an animal. So in a particular question like this, look, the dogs have ran on the grass to the point where the grass, unfortunately, has seemed to be destroyed, and it needs to be replaced in the circumstances. Is that fair wear and tear? It may well be, because unfortunately, or again, I assume that the lease agreement was allowed with pets. If we were in a circumstance where there were not pets allowed in terms of the premises, so pets were not allowed, then you can absolutely say that this is a circumstance where the tenant is fully liable for those damages, because they were not entitled to put the pets on. But if this is a circumstance where the pets were allowed and this is the resultant damage, there is a question about whether it's fair wear and tear or not in the circumstances. And our writer that wrote in said basically what they're looking to do is split it about half with the landlord. Maybe that is a reasonable way to assess the issue in the circumstances. But like with all fair wear and tear questions, be reasonable. You cannot expect that the property comes back in a pristine or better condition than it was. So try and work it out. It seems to me not to be an unreasonable ask in the circumstances. If as long as the property did recognize that some pets could be on the premises during the lease period.
Yeah. So yeah, thank you very much there, Nick. You've given us quite a clear definition, and obviously, each matter will be dealt with. It's pretty much circumstantial and on its merit. And then the last question, Nick, we'll be dealing with that one with you as well. The viewer here says, in my opinion, the levies referred to in clause 11 of the TPN lease agreement refers to municipal levies. It does not refer to the body corporate or HOA levies. In other words, tenants cannot be billed for the body corporate or homeowners association levies, or rent cannot be increased when the BC or the HOA levies increase. Am I correct in my understanding, Nick?
Perfect. So I've pulled up the section from the TPN lease agreement. It's one of the new versions, and obviously I'm not sure exactly what version the writer is on, but I imagine that this clause hasn't changed too much. And the way the clause reads is it says that if levies, rates, and or taxes in respect to the property increase at any time during the subsistence of the lease, the landlord shall be entitled to increase the rental to accommodate such increase in the levies, rates, and or taxes. Now, what's important is we're dealing with this specific lease agreement here. So this is very much geared towards the writer. And what is important in terms of the version that I'm looking at the moment is there is no definition for levies, rates, and or taxes. So the clause has been purposefully left open to interpretation. Okay. This is something that is often done in agreements where, for instance, in this circumstance, it isn't necessarily known at the commencement of the lease agreement if there will be increases in levies, rates, and or taxes, or if there are increases, what those increases might entail. You can have lease agreements for long periods of times where municipalities decide I'm going to implement a new rate, tax, levy. Look at if you're sitting in the city of Johannesburg, the recent implementation of the 200 Rand fee in respect of prepaid meters. That's something that came out of the blue. Absolutely, if you entered into your lease agreement a year ago, that's not something that would have been envisioned. So the point of this is the clause itself has been left purposefully open, so that it isn't defined exactly what levy they're talking about. So my interpretation of the particular clause is that it could mean either. Okay, depending, it could apply to either in the circumstances, and really when we're talking about body corporates and homeowners associations, those have a specific charge which they call the levy. The clause refers to levies, rates, and taxes because most of the things that are municipal charges are either taxes or rates for specific things, not particularly levies. That's more of a common thing in terms of a body corporate. But my answer in this particular circumstance is it's left open purposefully so that it can apply in either direction.
So yeah, thank you very much, Nick. So that does it for the clause 11 of the TPN lease agreement. And that does obviously also bring us to the end of today's question and answers. Thank you to everybody, and we'll see you guys again next week, Wednesday.
Thanks, guys.